Okay, I'm going to read the essay outline that helps write essays, basically. Issue spot in essays and the order of the essays. So here's the approach, the evidence problem-solving approach. Form. In what form is the essay question? In what form, in what sequence is the evidence introduced? And is there a question of counsel quoted? A, form of the question, narrative or transcript. B, forms of the litigation, state, California, federal, civil, or criminal. C, sequence of the introduction of evidence, plaintiff, prosecution, direct, cross. D, if a question of counsel is quoted, objections to the form of the question, leading, non-responsive, calls for a narrative, assumes facts not in the evidence, compound speculation, objections to answers. Purpose. What is the purpose of introducing the evidence? Logical relevance and legal relevance. I'm going to read this slowly because for whatever reason, this is the hardest part for me. Under logical relevance, the standard is the tendency in reason to prove more or less probable than it would be without the evidence. And the second point under logical relevance is special relevancy problems, similar happenings, experiments, prior suits or contracts, and negative evidence. Legal relevance. So under logical relevance, I don't really care so much about the special problems. What matters is the tendency in reason to prove more or less probable that it would be without the evidence. And I say that, I quote that right. That's easy. That's the easy part. Let's read legal relevance. Prejudicial impact versus probative value. And maybe it should go in that order, but I usually do probative value does not outweigh undue prejudice. Extrinsic policy exclusions is liability insurance, subsequent remedial conduct, settlement offers, payment or offer to pay medical expenses, and guilty pleas. And then character. So character is its own separate section, but in legal relevance, these policy exclusions are written within this section. So I think it's worthy to include them in the legal relevance equation, as well as needless accumulation of evidence, wasting time, and confusing or misleading the jury. I'm going to guess that that's part of the legal relevance, like 403 analysis and 352 analysis, which I know these analysis by number, so I know the rule. I waste a lot of time with having to write a different explanation for every piece of evidence. Character, part C. In civil cases, character and issue by virtue of the case and habit. In criminal cases, the defendant has to open the door. Mimic is a mnemonic for character evidence being introduced to show motive, intent, modus operandi, identification, and common plan or scheme. Oh, I forgot mistake. Absence of a mistake. Presentation. How is the evidence being presented? Witness, competency, age, and mental, personal knowledge, and impeachment. Doesn't say anything about willingness to be honest or give oath. For impeachment, using character witness, character evidence for the truth or veracity, or to show that a witness is not credible by evidence that speaks to whether they're honest or truthful. Looking to the form of character evidence is the next section under character impeachment, and that would be opinion and reputation in specific acts. Impeachment can also be achieved by bias, motive, defects in memory, perception, or knowledge, which are sensory deficiencies, and inconsistent statements, or consistent statements. Maybe not consistent statements. That could be for rehabilitation. Rehabilitation isn't here. So we're getting to the point where my issue spotting checklist is not as complete as what I know about this topic. Back to presentation, we're in a new section, document reliability. It just names authentication and best evidence rules, just to keep them in mind and don't forget arguing them. And opinion testimony, lay opinion, expert opinion, judicial notice, burdens of proof, and presumptions. The next section is hearsay. Any out-of-court statements introduced. The definition is out-of-court statements to prove the truth of the matter asserted, and they cannot be offered for its truth not offered for its truth and not hearsay. Some evidence is not hearsay because it is not being offered for its truth. However, for essay purposes, you should still separately head note and IRAC the hearsay issues. There's 4 types falling into this section. Verbal acts or legally operative facts, words of contract, defamation, effect on the hearer or the reader, for example, to prove notice in negligence case, circumstantial evidence of the declarant's state of mind, and non-human declarations by an animal or a machine. Non-hearsay is prior statements by a witness, prior inconsistent statement, prior consistent statement, prior identification, admissions, party, vicarious, adoptive, called tacit in parentheses, and co-conspirator statements. Exceptions to hearsay, ones requiring unavailability, are declarations against interest, dying declarations, and former testimony. Reliability exceptions include excited utterance, present sense impression, bodily condition, present state of mind. Documentary exceptions include past recollection recorded, business records and official records, and others are ancient documents, learned treaties, and the federal catch-all. Privileges are any privileged relationship involved, and then your approach to privileged relationships is professional and marital. Marital includes spousal testimonial privilege, confidential marital communications, confidential communication, holder of the privilege waived, and exceptions. So that's really all of the issues to consider as you approach evidence questions so that you don't miss any issues in your answer. Listen to this before writing all of your evidence essays.